The social worker's words came without warning. "We're here to investigate a report of elder abuse." The person accused of committing that abuse wasn't a stranger. It wasn't a hired caregiver. It was a son who had spent months visiting his dying mother 3 days a week, who had reviewed her medication list, done his research, and brought her 2 cans of her favorite drink on a pain-free evening. Here's the full story. Let me set the scene. A woman in her mid-50s, we'll call her Margaret, is in the final chapter of her life. Terminal liver cancer, diagnosed after years of compounding health challenges, decades of heavy smoking, morbid obesity, poorly managed type 2 diabetes, and a period of significant daily alcohol use. By the time the cancer was found, the window for curative treatment had already closed. There was nothing left to fight with. Only time. Margaret is receiving in-home hospice care. If you're not familiar with hospice, here's what matters for this case. It is not treatment. It is not about fighting the disease. Hospice care exists to provide comfort, to manage pain, preserve dignity, and allow a person to spend their remaining time on their own terms, in their own space. The goal is not more days. It is better ones. Margaret has several adult children. The one who shows up the most is a son we'll call Daniel. 2 to 3 visits a week, every single week. He brings groceries, handles small errands, sits beside her and watches whatever she wants on television. And one afternoon, she tells him she misses something. A drink. Her old drink of choice. Not a lot. Just a couple. Just to taste something that felt like her old life again. Now here is where the case cracks open, and I want you to pay close attention to what Daniel actually does next, because it matters enormously in what follows. He doesn't just go to the store. He pulls out her full medication list. He cross-references every drug she is taking against alcohol interaction data. He identifies a day when she is not on heavy pain medication. And then, only then, he goes out and buys a 6-pack of her favorite drink. Margaret drinks 2 cans. She is happy. By every account Daniel can give, it is a genuinely good evening. She goes to sleep comfortable, and the remaining 4 cans sit untouched in the refrigerator for weeks. He mentions it to his siblings in a routine family update a few days later, not hiding anything, not bracing for a fight, just sharing what happened. That is when everything falls apart. The siblings call it abuse, and one of them picks up the phone and dials Adult Protective Services. Now I want to take the siblings' position seriously, because they are not entirely wrong to be alarmed. Margaret has liver cancer. Her liver is already compromised. Alcohol is what's called a hepatotoxin, meaning a substance that is directly toxic to liver cells. In a healthy person, the liver filters and clears alcohol efficiently. In a patient with failing liver function, that process is impaired. The alcohol lingers longer. The cellular stress is real. That is a medical fact, and the siblings know it. The siblings also raise a question about capacity. Was Margaret, already facing death and likely on some level of medication, fully lucid when she made that request? Was she cognitively clear, or was she in a state of longing, of grief for the life she used to have, that clouded her judgment? These are not hysterical questions. In a family already stretched thin by a terminal diagnosis, these are exactly the kinds of questions a caring sibling might genuinely ask. But here is the counterintuitive angle, and I want you to sit with this one for a second. Margaret was not a child. She was not cognitively impaired. She was not under sedation when she made that request. She was a woman in her mid-50s, entirely lucid, who knew she was dying and asked for something that brought her genuine joy. Daniel did not pressure her. He did not deceive her. He honored her. What would you have done in his position? I mean that as a real question. Let's talk about the legal framework, because this is where most people are surprised. Adult Protective Services, APS, is a government agency responsible for investigating allegations of abuse, neglect, and exploitation of vulnerable adults. In most states, a vulnerable adult includes elderly individuals and persons with serious medical conditions in a dependent care setting. Anyone can file a report. The threshold to open an investigation is intentionally low, but substantiating abuse. That requires a significantly higher standard of evidence. There is also a legal doctrine running directly through the center of this case: patient autonomy. In American medical and legal tradition, a competent adult has a recognized right to make decisions about their own body, including decisions that may shorten their life. This is the same legal foundation underlying advance directives, do not resuscitate orders, and the right to refuse chemotherapy entirely. A dying woman asking for a beer is exercising that exact same right. And then there is the hospice standard itself. The National Hospice and Palliative Care Organization explicitly states that in end-of-life care, comfort and quality of life take precedence over clinical optimization. Some hospice programs maintain what are called comfort-focused alcohol policies, meaning a modest amount of a favored drink is not categorically prohibited for terminal patients. The governing priority is not to maximize the number of days remaining. It is to honor the days that are left. The APS investigation moves forward. An investigator visits the home. Standard procedure requires a direct interview with the alleged victim to assess whether she is in immediate danger and whether she has the cognitive capacity to make decisions for herself. Margaret is alert during the interview. She is clear and oriented. She communicates without confusion. She is, by every measurable indicator, not in distress. She knows exactly what happened. She asked for it, and she says plainly that she would ask again. The investigator reviews Daniel's decision-making point by point. He checked her medication list before purchasing anything. He waited for a day when she was not on heavy pain medication. He was physically present the entire evening. He did not coerce or pressure her. She drank 2 cans voluntarily and stopped on her own accord. The remaining 4 sat in the refrigerator, untouched, for the following several weeks. Every detail in the record points in the same direction. But the siblings are not finished. One of them has retained legal counsel. Their attorney files a formal motion arguing that Daniel acted unilaterally, without consulting either the family or the hospice medical team. They argue that any alcohol is medically inappropriate for a patient with active liver cancer, period. And in a maneuver that stuns even the opposing side, they ask the court to legally restrict Daniel's access, to bar him from his mother's bedside entirely. I need you to pause and fully absorb that. A sibling is arguing in a legal proceeding that a man who spent months at his dying mother's side, 3 visits a week, every week, without missing, who brought her food, who sat with her through pain, who checked her medication list before buying 2 cans of beer, should be legally prohibited from seeing her, barred from her bedside, while she is dying. That is what was placed before this court. Then the hospice medical director is called to provide testimony. This is the moment the case turns. The director confirms that Margaret's care team was fully aware of her complete medical history, including her prior alcohol use. They confirm that comfort-focused palliative care is the governing standard in her case. And then they deliver one detail that stops the siblings' attorney mid-sentence. The hospice team had already discussed alcohol with Margaret. They had not prohibited it. The investigator's final report is submitted. The finding, unsubstantiated, there is insufficient evidence to support a finding of abuse or neglect. Daniel researched before acting. He waited for the appropriate day. He remained present throughout. He honored a terminal patient's explicit, informed, and competent request. The APS case is closed. No charges filed. No referral made. Closed. The siblings' legal motion to restrict Daniel's access is denied. The judge, reviewing the full evidentiary record, issues a clear finding. Margaret is a competent adult with full decision-making capacity. She has expressed, directly and without ambiguity, that she wants Daniel present in her home. No court possesses the authority or the inclination to override the stated wishes of a dying woman about who may sit beside her. The judge goes further. In his written ruling, he notes that the motion appeared driven less by genuine concern for the patient's welfare and more by grief and unresolved family conflict. He recommends that all parties seek counseling. And then he includes a line that has stayed with me since I first read this record. The patient is the client, not the family, not the adult children who arrived to fight over her final days. The patient. There is no dramatic gavel drop here, no gallery erupting. Just a man walking out of a courthouse knowing he can go back. He can sit in that chair beside his mother's bed. He can bring her what she asks for. He can hold her hand through television shows and quiet evenings and the hard moments that come at the end of a life. Whatever time she has left, she gets to spend it how she chooses, with the people she chose. Margaret passed away approximately 6 weeks after the ruling. Daniel was there. He had been there 3 days a week, right through to the end. The siblings were largely absent in those final weeks, caught up in their own grief, some said, or perhaps struggling with what the proceeding had revealed about the choices they had made. Daniel has said publicly that he doesn't hold a grudge. That grief makes people act in ways they wouldn't otherwise, that he understood, even when it hurt. This is not a landmark case. There is no citation in a law school casebook. but it represents something thousands of families face every year and almost never discuss publicly: the collision between medical caution and human dignity at the end of a life. Who decides what a dying person's final weeks look like? What does love actually look like when medicine has run out of answers? Those questions do not resolve cleanly. They stay with you. What do you think the right answer was? Drop it in the comments. If this case resonated with you, I want to put one resource in front of you. The National Hospice and Palliative Care Organization publishes a free guide called Caring Connections. It covers patient rights, family conflict, and end-of-life decision-making in plain language anyone can understand. Link is in the description below. And if you want to see a case where a family dispute like this one escalated all the way through probate court and a full guardianship battle, that video is queued up right now. I'll see you there.